It's good. This Global IP Congress helped me get rid of the Zoom fatigue.
Mhm.
So many different topics and so many different things and people that it's almost like, opening a new Zoom world. But we're back on CDL today. So I don't know who's deciding when it starts. It's probably me. So I will start since we have the speakers. I do not have access to the audience, I think. Oh, there's 21. Anyway, welcome.
Hello, you can start now.
Okay, great. Thank you. That must be Diego. No? But thank you. Welcome. My name is Manon Ress, and I work for Knowledge Ecology International in Washington, D.C. And I will be the moderator of this timely panel on control digital lending in a pandemic. I would like to thank the organizer actually for accepting this great panel, which is really a good time for us to do it since we are all struggling. We have a great list of speakers, and they will have about 10 to 12 minutes to make their initial comments before a discussion, which I hope will be lively and should be lively since there are so many ways to look at what libraries are doing right now in the time of pandemic. But first, let me introduce you briefly to the issue that we'll focus on. So while we are all, in one way or another, dealing with a global pandemic, which makes in many countries access to school and libraries, if not difficult, in some cases impossible. And it should be like this to ensure safety for all of us. There's really a problem of access to knowledge and information that is creeping in everywhere. At the same time, we all know that the fundamental socially beneficial function of libraries in all parts of the world actually is to provide broad access to information and learning material. And this fundamental function is more than ever crucial to ensure economic and maybe one day cultural recovery. I'm an optimist, and I think that we will make it through. Now, under different laws, and that's what we're going to explore today, or community practice or cultural practices, I think libraries lend books and other materials. Right now, we are all struggling to find a way to access books. And many of us, including me, are counting on digital format for books and learning materials. Whether you're in first grade, which is a 6-year-old in the US, or a student, a graduate student, or a worker, we are all trying to find access to learning materials. So in the US, but we will talk quite a bit about the EU and the international situation, we are relying on what we call controlled digital lending, CDL. I hate acronym, but that's why I'd like to say controlled digital lending, but to make it shorter, we'll say CDL. And it's not a brand new concept at all. And there are already multiple versions of CDL. Some CDL systems are statewide in the US. Some are county-wide or city-wide. I mean, some state in the US are developing system of lending only to residents of that state, for example. Some are institution-wide, and that's many schools or many school districts or many universities say only people enroll in that school or district. And very few, but there are some, are as truly global as the pandemic, and that would be probably the Internet Archive, which is very easy to get access to in any jurisdiction, actually. But now, the practice of controlled digital lending is really designed to mirror exactly what traditional library practice with strict rules, such as the use of TPM, technology prediction measures, and digital rights management. And they are actually pretty strict. We talked to somebody who's actually selling some of the software, and they all kind of different, but they all do their job. They control the access. So books are scanned, and they can be borrowed and read by as many users that there are copies, physical copies, in the institution or library or school. One book, one scan, one reader. And all the DRM of the world and all the TPM of the world are in place to control that fact. I myself went on the CDL system to get some books, and I'm a slow reader. And after 2 weeks, I had to try to get that book again because poof, disappeared. In addition, of course, you cannot download the book. You cannot send the book. This is really a very controlled environment for access to knowledge. So a good definition of, a more learned definition of controlled digital lending can be found in a white paper by David Hansen and Cal Courtney, who are quite famous in the world of CDL. They say, basically, CDL enables a library to circulate a digitized title in place of a physical one in a controlled manner. And I think under this approach, a library may only loan the same number of digital copies that they have physical copies in their collection. Now, libraries first have to buy the book or get it through a donation. In the US, because CDL is really something that's very widely known in the US, but maybe not in all part of the world, the practice of CDL relies, I think, but you'll have specialists getting into the deep dive of this issue, relies on two important US doctrines, the fair use and the first sale doctrine. These two doctrines, which is section 109 for the first sale and section 107 for fair use, are the pillar for CDL. And in brief, some of you may know that the first sale doctrine is not a new thing. It's very old in US jurisdiction. And basically, if you buy a book, you can do whatever you want with it. You own that book, you can lend it, sell it, destroy it, give it to your friends. Without it, it's obvious that the copyright holders could enforce rights in the secondary market, which would impact selling, loaning, gifting any copyrighted work. So that would not even be feasible in the physical world. Like the first sale doctrine, fair use is also widely used in the US and is also used by industries. I mean, whether a home recording device manufacturer, search engine, filmmakers, publisher, they rely on fair use. It's something that's clearly not new. It started in the 1800s, I believe, and was more codified in 1976 in section 107 of the copyright law. But it's something that is traditional, basically, in the US. And I won't go through the four non-exclusive factors that courts and users should consider, because this is getting into the nitty-gritty that probably the speakers will talk about. But I did add to the chat section 107 and section 109, the text, if you need to look at it while people talk. But there are four factors, and they are taken very seriously in the US. Unfortunately now, the global pandemic is causing many stakeholders to act very quickly and to do sometimes take position on CDL that could have negative impact on access to knowledge and information. The IP owners organization, whether in the patent world, and we see that in the access to medicine movement, or the copyright world, are on the defensive. And in some cases, they're even benefiting, actually, from the pandemic crisis. When it comes to drug issues, sometimes we talk about profiteering, but there's profiteering in many other ways in the copyright world, too. And I think that, in a way, licensing is one of the issues that we should address today about is CDL an alternative, or is CDL replacing licensing? But the goal is to hear the speakers, and I hope you understand that there's a three-step test in some countries and specific exception. In some countries, there's not even public lending at all, so that's a totally different ballgame. And then there's the fair sale doctrine and fair use in the U.S. and in many other jurisdictions, of course. So I will start with asking Corinne Mike Sherry, who's here. Yeah, she's muted. She is the legal director at the Electronic Frontier Foundation. She is well known and specialized in intellectual property, open access, and free speech issues. As a litigator, her favorite cases involve protecting online fair use rights, political expression, and the public domain. She has represented wide variety of clients, including a dancing baby that I'm sure you all saw on your social network, environmental activists and public interest organization dedicated to improve access to knowledge, including, and more importantly today, the Internet Archive. She's also very much involved in policy work, and she testifies in Congress on a regular basis. And I'm going to give Sherry the floor. I think she's muted. I don't know if somebody, yeah, okay, cool. So I can mute myself.
Okay.
You have the floor.
Thank you so much. And thank you everybody for joining this conversation, which I hope really will be a conversation. So I'm going to try to keep myself as brief as possible so we actually have time for that. As Manon just mentioned, I do represent the Internet Archive. The Electronic Frontier Foundation represents the Internet Archive in connection with some litigation around controlled digital lending. And so while I can say many things, I might be just a little careful sometimes so that I can protect privilege, because that is, of course, my first obligation to my client. That said, there's quite a bit that we can talk about, because there's quite a bit that's just completely on the record and clear and understood and no great secret. Let me just hit on just a few of those things. First, I think it's important to understand some facts about the Internet Archive's program. There's a lot of different forms of digital lending, but the Internet Archive's program is, I think, the one that's sort of come to the fore just recently in the context of this pandemic. The sort of core thing to know about the Archives program and about controlled digital lending in general is it's simply doing what libraries have always done. Right? The Archive does what libraries has always done. It buys, it collects, it preserves, and it lends books. Core library job, right? And unfortunately, though, there's a lot of misinformation about that. So let me break down exactly what happens. So under CDL, the Archive and other libraries simply take books they already own, and then they lend out digital scans of those books on an own-to-loan basis, meaning they only loan out one copy of a book they already own to one person at a time. That's the basic principle. One person can borrow one copy at a time. And then they take their physical book out of circulation, okay? And that's really important. We have to do that now because in many places, and this is even before the pandemic, people can't always get to the library. They can't always get access to that physical book. So digital lending is filling a very important gap. But it's also not new. So the Archive has been working with hundreds of other libraries since 2011 on this controlled digital lending project. Again, the books are lawfully acquired via purchase or via a donation. The Archive uses, as Manon mentioned, technical protection measures, standard in the industry. And I will tell you that my organization, EFF, is no great fan of DRM. But at any rate, this is what is being used here to make sure that the own-to-loan process is working correctly. Libraries, including the Archive, but all of the libraries that participate in the network have paid publishers billions of dollars for these books, right? They've already been paid, they're all purchased lawfully. There's nothing piratical about the whole situation. And libraries have already paid for these books and are investing huge resources in digitizing them because it's the 21st century and that's what you have to do. CDL helps libraries take the next step and loan out those books that they digitized, books that they, again, have bought and paid for. It's not very different from traditional library lending that publishers don't love either, but nonetheless is actually, I think, good for access to knowledge and good for authors and good for readers. It's good for the public. And another thing, though, that it's doing, that the Archives program does, is also doing a little bit more. It's fostering further research and learning by making sure that books that, for example, are out of print are still accessible, which is a great thing. And a good thing for authors, by the way, because one of the things I think that many authors find frustrating is their books go out of print and suddenly they're not so accessible anymore. The archive helps remedy that problem. So it's a good thing for authors, or for many authors. But that said, I mean, I could go on about the public benefits at some length, but at the same time, if you're an author or a publisher, if you're a copyright owner and you don't want your book in that collection, the archive will take it out and will do so expeditiously. Okay, so that's some facts. Let's talk about the law. And I'm a US lawyer, and so I'm just going to focus here on US law. As Manon has suggested, we believe, and we are quite sure a court will ultimately agree, that CDL is protected by the fair use doctrine, buttressed by a host of kind of very traditional library protections like first sale. For those who aren't, I think most of the audience here is going to be pretty familiar with fair use, so I'll just be quick about it, but I know there are people who are not in the United States and I don't want to assume too much. But under US law, fair use is an evaluation based on 4 factors. You look at the purpose of the use, you look at the nature of the original work, you look at how much of the original work has been used. Did you use more than you needed to for your purpose? So those 2 factors go together. And has there been harm to a market? Is there a substitution to the market? And then you consider all of those factors in light of the purpose of copyright, which is to promote the public interest by spurring new creativity. Okay, so you look at all those factors together. Now let's apply them to the archive situation. Well, first, what's the purpose of the project? It's to serve the public interest in preservation, access, and research. It's entirely non-commercial. These are all classic fair use purposes. So factor 1 goes that way. Factor 2, every volume in the collection has already been published and most are out of print. And so that's relevant to thinking about the nature of the work. You think about, is it published or not? The amount used. Well, entire volumes are lent out, but that's what you have to do if you're engaging in lending. So it serves the purpose here. So no more is taken than you need for the purpose that you're after. I mean, that's what it means to check out a book from the library. That's what you do. In terms of harm to the market, the books have already been bought and paid for by the libraries that own them. And then when you think about sort of the general public interest, which courts more and more attend to in fair use analysis, there's no question but that the public is deriving a huge benefit from this program. And on the flip side, rights holders gain nothing if the public is deprived of access to this resource. Last, let's talk about context. Okay, I think it almost goes without saying, but I'll say it anyway. Right now, this kind of activity is just essential. So many people around the world cannot access libraries, even in their own hometown. We have a dramatic increase in distance learning, and I think that's going to continue for a while, unfortunately, and we do not have a dramatic increase in education budgets. At least I haven't seen one. I'm pretty sure it doesn't exist. Okay, so we have a problem. We have a lot of people who need books. They need books to learn, they need books to read, they need books to pass the time, and they need books to do research. How are they going to get them? Well, one of the ways that they're going to have to get them is via digital lending. That is exactly what CDL makes possible. So last thing I want to say is that unfortunately there's some rhetoric on the socials and in lots of other places that's trying to portray the archive and trying to portray CDL as some sort of piracy. And we have that kind of familiar rhetoric, unfortunately, in copyright circles. The archive, the Internet Archive, is not a pirate. The libraries that are working with it, they're not pirates. They're not thieves. They're people who are trying to serve their patrons. They're people who are trying to do in the 21st century what they have always done, which is to preserve and lend books. They're doing what they've done for centuries in the brick and mortar world. And copyright law does not forbid it. In fact, it's good for authors, it's good for readers, it's even good for publishers. So copyright law does not stand in the way. And that's a really good thing. That's a good thing, because we don't want a situation where publishers become the final arbiters of what we get to read and share and how we do it in the digital age. And I'll close with that. Thank you. Happy to answer any questions, but I'm looking forward to hearing from the other speakers as well.
Well, thank you, Corinne. It's very interesting, and I would add to your. It's not about pirates. I would add that libraries are the biggest buyers of books. They are the biggest clients of the publishing industry. So to transform to talk about piracy seems totally bizarre. It's like accusing your best client of doing something wrong. Well, in fact, the best client is buying so many books right now, even now, even though the budgets are going smaller for libraries, they're buying more books than ever. But we're going to talk about the situation in Europe. And I have Augustin Reyna, who works as a senior legal officer and digital team leader at BEOC, which is the European Consumer Organization. And within BEOC, Augustin follows the EU development around consumer rights in the digital environment. He led the digital team coordinating the policy in the area of copyright, data protection, telecommunication, and competition. He was he's been since 2017 the EU co-chair of the IP group at the Transatlantic Consumer Dialogue, which is a federation of 75 consumer groups, both in US and EU. And lucky for you, he also knows quite a bit about Latin America because he's a native of Argentina too. So he's the perfect person for us to explain what's going on in Europe and beyond. The floor is yours.
Thank you very much, Manon, for the invitations and to the organizers for putting together such an interesting event. Coincidentally or not, we have been actually discussing this issue from a transatlantic perspective last week, and actually as a result of that, I think many of you have been also part of that discussion, and I think that we can bring a little bit forward what we have already discussed and see how we can actually facilitate, at the end of the day, access to knowledge and information for so many readers around the globe. So my contribution to this panel will be more on the EU perspective. And I can tell you that it seems that controlled digital lending is not happening in Europe yet. And the reasons for that, they're also rooted in our legal system. So in the EU, unlike in the US, we don't have a fair use based system. We have what is called an exemptions based system. So basically, copyright law provides for the exclusive rights or the economic rights of the right holders, and then exemptions to those rights. But we do have, like in more jurisdictions across the globe, the first sales doctrine. But the first sales doctrine does not apply to digital copies. with exemption of computer programs, but that's a separate discussion. But when it comes to books and ebooks, they are not subject to the first stage doctrine. So that means that right holders can control what happens in secondary markets. But when it comes to lending, we have a special regime, which is regulated in the rental and lending directive. And this regime actually provides for conditions in which lending of books take place by libraries. However, this is a directive of 2006, so quite some time before the distribution of books online, and especially by libraries. So actually, we have actually a quite interesting case at EU level. So we have the European Court of Justice that have interpretative power to clarify the compatibility, for example, of national legislation with EU law. In this case was a Dutch case in which it was questioned to what extent the regime that applies to the lending by libraries of physical books can be extended to ebooks. And the court made extremely interesting and important reasoning, which basically says that the lending or the definition of lending and renting in the context of the directive is technology neutral. So it does not really matter which technology you use to lend books, as long as the conditions are fulfilled. And therefore, lending also covers digital copies, provided that, of course, they come from a lawful source. And in that ruling, the court made an interesting reflection, which actually acknowledged the need for copyright to adapt to the technology and the economic realities in which we live, and seeing the important role of libraries as enablers of access to knowledge. Clearly, online and digital lending plays an extremely important role to fulfill this mandate that libraries have. And if we look then at the context of controlled digital lending, what if controlled digital lending will take place in Europe if libraries, for example, will scan copies of books in order to lend them virtually? The conditions that actually needs to be fulfilled according to the law is actually it needs to be made available for use during a limited period of time without direct or indirect economic advantage for exploitations, and authors have to be remunerated. How are authors actually remunerated? Through the lawful acquisition of the book, either because the book they have bought directly by the libraries, or because they have been donated. But that physical book, the sale of that physical book, had been actually the remuneration of the relevant right holders. Of course, and in Europe and national level, so each country can adopt additional conditions as long as they are compatible with the spirit of the legislation. For example, that books should have been put in circulation first before the lending takes place. However, we have also seen, and that's have been actually reported, and I hope that my colleagues that are in the librarians community can actually explain that better. Sometimes the legislation is not so clear. And there is with legislation not being clear, that means that there is a risk for the libraries of being sued. And libraries, they actually cannot afford being sued and going through, very extensive proceedings and risk having to being condemned for paying damages. So clearly, having unclear legislation does not help to facilitate this type of lending. And the feedback also that we get is that in Europe, this type of lending does not happen, not even the lending of ebooks in the exercise of the exemption, because most of these type of lending is covered by licenses. And that means that actually, if it's covered by licenses, those institutions or libraries that can afford licensing are those that are able to offer it, because of fears of being sued. So basically, only the rich institution at the end of the day are the ones that can afford this type of lending, which adds as an additional problem the risk of having to face, unfair terms and conditions, terms of use, because here we are entirely in the field of contractual freedom. And as we have learned in copyright law, right holders enjoy a quite broad contractual and technological freedom to decide how the works are exploited, which also have led to conflicts with not only exceptions and limitations, but also with fundamental rights. I did actually, after our discussion of last week, a little bit of research, and unsurprisingly, right holders and publishers are extremely against controlled digital lending, even if it's not happening in Europe. But still, the role of a library is far too important to leave it to commercial and contractual agreements. And as it was mentioned before by Corinne, we cannot just simply replace the role of a library, and certainly in times like the times that we are living today, that force us to adapt, and controlled digital lending is a way to adapt, but that does kind of come at the expense of libraries, bearing a huge risk of being sued for just simply trying to fulfill their public mandate. So I will stop here, and I look very much to the discussion. Thank you, Manon.
Well, thank you very much, Agustina. I really like what you said about the publishers are very much against CDL, even though it's not happening in Europe. And that goes with what I'm feeling is going on in times of pandemic. It's the circle the wagon thing, where all the IPRs owners are on the defensive and on the attack. On the defensive in the US and on the attack everywhere else, when in fact they should be participating in saving our culture and helping with the recovery. But we have now Stephen Wider, who is the manager of policy and advocacy at the International Federation of Library Association and institution, and they represent all types of libraries globally. He leads on work to help libraries strengthen their advocacy for the support and laws they need to support equitable, universal access to information. He works also on internet governance, human rights, sustainable development, and cultural heritage. And I know Stephen very well because we sit next to each other at many WIPO meetings. And I'm leaving the floor for him. He can talk for the library institution globally, for sure.
Thank you, Manon, for the invitation. And I think it's almost getting to the stage where I'm missing those chairs at WIPO that can't get out of. So I'm almost looking forward to getting back to those. So briefly, just to explain, so IFLA is the International Federation of Library Associations and Institutions, and we are the global organization for libraries of all types. So the school libraries supporting schools, public libraries supporting communities, people throughout their lives, the big national libraries, which are copyright libraries, academic research libraries throughout. And obviously our members work in very different jurisdictions under very different sets of laws. So a challenge like, no, not a challenge, an initiative like controlled digital lending is always fascinating because it both highlights what's possible and it highlights all the frustrations that come from different approaches from one country to the next. To give a very brief idea, I think people will be aware of the challenges that libraries have faced during the pandemic, in particular the frustration that so many of the works that have been legally acquired in physical copies are just stuck behind the doors, where according to public health rules, you're not allowed to give access to them. At best, you can provide curbside pickup or delivery services. And this is obviously firstly causing this frustration, but also forcing libraries to turn to what is in the end a highly unregulated digital content market. It is a wild west. Agustin underlined that freedom of contract reigns supreme, and they're being forced to see this huge difference between a relatively regulated physical market and an unregulated digital one. Clearly also libraries are facing the longer term issue of the growing disconnect between the ease of working digitally, the expectations of users, and of course, as has been mentioned, the potential to do things securely to control the number of copies out there and what the law permits. So in terms of how libraries have experienced controlled digital lending, as users, it's been relatively widely encouraged, and not just in the US and Canada. So I was happy looking around, and we can see libraries in Uruguay, in France, in Spain, in Haiti, in the UK, and others recommending to their students that they should take a look at what they can access through controlled digital lending. This has been a huge issue for many historical works, artworks, a lot of social science works, which might otherwise not be available at all, or only available through interlibrary loan slowly. And of course, I don't know, as everyone has said so far, it's been a fantastically powerful resource during the pandemic. It has also been true that so far the main examples, it's mainly been libraries in the US, but also Canada that have actually made their collections available. As Agustin mentioned just now, and Julia Rader underlined at last week's Transatlantic Consumer Dialogue meeting, often this is because libraries are not really risk takers. They don't have the legal team at their disposal. They need the precedent, the guarantee that what they're doing is safe. This obviously isn't helped by the fact that the right holder lobby tends to be very ready to reach out for their copy of Nostradamus whenever something appears on the horizon and predict the end of the world, because a great way of scaring libraries off is when there's a massive political shout out, a massive sort of scream of pain. This is a pretty effective way of encouraging libraries not to go there because it looks dangerous. So even that sort of comms effort, which in the end it is, can have an effect on behavior by discouraging activity, by discouraging engagement. Nonetheless, we have examples that are there outside the US, and Canada is a good one because it shows that you don't necessarily, or we currently believe it shows that you don't necessarily need fair use in order to make controlled digital lending work. At least in Canada, the suggestion at the moment is what you need is just a good research and private use exception, exhaustion per sale, and some measure of technological neutrality. These aren't criteria, these aren't characteristics that are reserved to Canada. What is noteworthy that is in the case of Canada, the focus appears to be mainly on out of commerce works. So there's a really interesting legal opinion for Hamilton Public Library in Ontario, which suggests that Canada's fair dealing factors, and in particular consideration of the nature of the use and its effect on markets, speak in favor of giving access to out of commerce works through controlled digital lending being perfectly possible. We see the same from the University of Alberta, which has made collections which are primarily out of commerce, some in the public domain, available in this way. There's also a really good example, which I encourage everyone to look at on the Internet Archive's own blog about Aruba, which highlights the potential of controlled digital lending to act as a platform for providing access, especially for smaller language communities. It's worth mentioning, of course, that Aruba is technically part of the Kingdom of the Netherlands, and so it is sitting under this sort of exemptions type law, but they've looked to make it work. In this case, the library was able to make use in particular of the National Emergency Library in order to support learning in Papiamento, the local language, while schools were physically closed. Doubtless the fact it's a small community made it possible to identify authors and make works available more quickly. But it's also interesting in terms of giving libraries a model, a platform, of sparing them the expense of setting up their own platforms or having to go through a big commercial intermediary, which often brings extra costs and brings a sort of black box element to the whole thing. It's worth underlining, and I think this has come out a little bit already, that these provisions aren't particularly crazy. Agustin talked about having e-lending provisions in Europe, which underline that digital copies of works can be lent out thanks to the CJEU judgment that's been already presented. I think An interesting challenge for the coming months, years, would be to test clearly the question of whether a digitized version of a physical book can be lent under these provisions, not just books that have originally been acquired as ebooks. This is potentially powerful because, of course, commercially available ebooks tend to come covered in contract terms and technological protection measures that make it impossible for libraries to use them for lending. Clearly, I don't know, there are also examples from the Orphan Works Directive, the Out of Commerce Works provisions in the Copyright and the Digital Single Market Directive, which would even achieve something similar to the National Emergency Library. Of course, in these situations, there are major questions about how to ensure that the conditions that need to be met in order to deliver on these possibilities, as well as the infrastructures in place, are appropriate. Going back to areas where it will be interesting to look at what's possible or not under current laws, there may be scope in the UK, Australia, and others where there are fair dealing exceptions, relative flexibility on shifting between digital and physical, and exhaustion principles to act. And we're just seeing recently in Australia some quite high-level proposals in order to increase possibilities for libraries in order to provide digital access to their collections. And that's really going to be one to watch. Of course, when that happens, there are questions that come up around public lending right, either because lending is covered by copyright, which is the case in the UK and is the case for e-lending now as well, or because there's separate legislation on this as in Australia, or because you just have a public lending right body in Canada, which may require that if you're going to lend, you need to pay. Other areas of law which may be interesting and which can be seen as parallel to this are traditions of document supply and interlibrary lending, which have long taken place within countries, across areas, across borders. It's another interesting angle to look at. Now, looking forward, I think these sorts of tools, controlled digital lending, has a really interesting potential to help libraries show their value in a digital age. It does cost money for libraries to preserve a book. Even when you take digital copies, you need to upgrade the formats from time to time because they disappear, they die off. So libraries do spend money. There is a cost in preserving works. When you can give access to them, this increases the value. Now, we know that cuts are threatened, have already happened. There will be more pressure on spending. If we don't allow libraries to deliver on their missions, to show the value of their investment in these books, there's a risk of this value being brought into question. And arguably, if we lose that, we lose the potential for libraries to contribute to the cultural recovery that Manon mentioned at the beginning. There's also the interesting question for libraries that can controlled digital lending provide a fallback, a sort of idiot guard, ensuring that libraries wanting to make their collections available have an alternative if they can't get good terms for licensing. This could help ensure that the discussions we hold are not so much about value capture, about extracting revenues for every single use by libraries, but rather about being able to engage in a discussion with rights holders about how you can come up with models that really provide better value for libraries. Because in the end, especially with more modern books coming out, what libraries need to be able to do, they don't want to buy 50 copies of a book. They want to have a license where you can buy one copy and lend it out 50 times at the same time. Controlled digital lending doesn't provide an answer for that, but we can actually move on to that discussion of how we get better licensing models if there isn't always the risk that the publisher can just say, no, you can't do that, nothing is possible. So I think CDL has a really interesting potential here in enabling us to move the discussion on for libraries when they're getting involved in licensing discussions. That's me done. Thank you.
Thank you, Stephen. It's very interesting. CDL is really showing what is possible, and I understand your frustration. But we have a very short time, so I will introduce Luis Villarreal-Villalon, who is the director of Innovarte. He's been Minister of the Industrial Property Court of Chile, intellectual property advisor to the Ministry of Education, consultant for the legal department of the Latin American Development Bank, advisor in international reforms and negotiation on IP to Ecuador, Uruguay, UNESCO, IFLA, World Blind Union, among others. I know him at first as a delegate of Chile at WIPO, where he was one of the most impressive delegates who would take the floor. And he was one of the power behind the push for the Treaty of Marrakesh for the blind and people with disabilities. Again, I'm thrilled to have Luis on board here on CDL board. The floor is yours.
Thank you, Manon. For me, it's an honor and a pleasure to be with such a group of experts and well-intended activists. Well, first, I would like to start saying that it's surprising, that we are discussing, how could we do control digital lending in a time of a pandemic where we all be thinking on how to punish those libraries who do not provide controlled digital lending, because unless you do control digital lending digitally, you are exposing the life of many, and the explosion of the pandemic because of the access to books that we know that we cannot function as a society without them. So my first thing is that the controlled digital lending is not only an issue of access to knowledge, but also is an issue of access to life, and it should be seen as a need and a mandate for all libraries in the world. So I think that we should start thinking that this is an issue of national security, the world security, and we hope that the government understand this before it's too late, especially when we see that there is a push for reopening schools and reopening, normal life, but each book might be a weapon of mass destruction. So we need to really play digital. Saying that, I would like to go to three ideas. First is the justification from the point of view of normal copyright in normal times, and the possibility of countries to adopt controlled digital lending, and the international frame that allow it or restrict it. So with regard to the justification, and is my dog barking too loud? Well, can't help it. So the first thing is that from a Latin American point of view, the reason to have a digital lending, controlled digital lending in Europe, it expands much more in Latin America, where we have seen that even some ebooks that are available in Europe and the United States are not sold, are not licensed in Latin American countries like Chile. We have a case of, I was just researching to prepare this presentation and asking the libraries, if they have some cases, and yes, there are some cases that very recently, like 3 or 4 days ago, with regard to a books of Julio Cortázar that you will see in the PowerPoint. So we don't have even enough ebooks. And also we have the issue that even collective societies have not updated their rules to request a license for something like a controlled digital lending. If you go to a collective society and ask them, how much do I pay? Well, they don't provide for the service. So in addition to the health need and the cultural need, we have a clearly a market failure that also is creating a problem to access. So, but there is an additional issue that also has been highlighted in the case of Chile. Consulting with our friends from the libraries, they have seen there has been an increase in the cost of ebooks around 25 to 35% from the previous year. So it shows that there has been an abusive behavior, on the ebook market. And also we have numbers of how much have changed, obviously because of the pandemic, on the use of physical books, the request, in some libraries of a university in Concepcion. They told me that in 2019 they have a 60% use of print and 40% of ebooks on the patrons, and now they have moved to 95% of access to ebooks, and only, of course, 5% to physical books. So we see that it's an urgent need of more access through digital means. So the question now is, what does national law provide to allow this type of uses? And first, if we take a look on all regions, Europe, US, you will see there is from the national law perspective, a very big variety of options. We see in the case of the Europe that you have a right of lending for the author, but an express exception for lending. So that gives some room to make an interpretation of this exception, express exception providing lending. And in the other hand, you have the US who do not provide for a lending right nor a lending exception, but they can play with a flexible solution that will be fair use. In addition, in the US, as far as I understand it, they don't recognize expressly the right of making available provided in Article 10 WCT, and instead they play with reproduction and distribution right, which gives a lot of role to exhaustion, which is not the case if you are in a country where you provide express making available right. So there is a difference, and if you look to Latin America, you will see that some countries provide for lending right and exceptions, and in other cases there is no lending right and there is no exception, and in any case none of them have a flexible solution. So we have to rely on express exceptions, and that's a big problem, because if you see express exceptions, you won't find anything that might meet controlled digital lending as we have defined it. And even in many cases, you don't have exceptions at all. Remember, I will ask later, Agustina, how they do in Argentina, where they don't have express exceptions for libraries, or in the case of Uruguay, they don't have none at all. So definitely everything is going under illegal if they do something. So as a first conclusion, we see that the solution that we might find in the US that works, it might not be the solution for us in Latin America, and vice versa, because of the different the law. So we need to look above to look international law. What does international law tell us? But before to go into international law, a positive note that is, even that we don't have express exceptions, in Latin America, some countries have other exceptions that might be helpful and serve a partially the purpose. For example, in Chile and Ecuador, we have an article that was built based on the EU directive possibility of digitalization and making available in terminals within the library. We expanded in a reform that I took. I was advising that we advised to have an exception that allows the library to provide digitalization for all their books, but making available not to terminals within the library, but terminals related to the institution. So you might interpret this that you can access at home, as long as it's within the server of the university. Although, of course, you cannot download, you cannot make a copy, and you cannot take it to a server different than the server that is coming from the university. So there are some space, and there is some practice that can also be modeled within the Latin American examples. But let's go to international law, which is, I think, is a key issue, considering that we need an international solution. And again, the frame for international solution will depend on which country you are, considering that there are different treaties that affect what you can do. But but starting with the TRIPS, in TRIPS, I don't see there is a problem at all with controlled digital lending, especially because TRIPS don't, in Article 6, they expressly rules out the issue of liability with regard to exhaustion. So any country might provide whatever they think on exhaustions of right, Article 6. And also TRIPS do not provide for lending right, don't provide for distribution right, and even not for making available right. And the reproduction right in TRIPS is understood not to be digital reproduction because of the fixation requirement in TRIPS. Okay, 4 seconds. The left, I've been told. So, so, so in TRIPS, we have a very good ground to provide a solution, not only because of there is not mandate on some core rights, but also because TRIPS allows you to have a limitation to the right based in national security, which is Article 73, and also you might limit the in injunctions or the enforcement based in Article 44(2), which is a sort of compulsory licensing that applies to any type of right. So I think, and I'm finishing with this, is that TRIPS is a solution. We have seen that there is a great proposal from India and South Africa, supported by some of the NGOs here, asking some type of waiver for TRIPS obligation, and I think that the international community should support it as well. And I stop here before Manon digitally explodes me. Thank you.
Oh, come on. I was just reminding you because you could go on, and I would love to listen to all these details.
Okay. But I have something more to tell about the WIPO copyright treaty, but happy if you ask me a question.
Maybe in the discussion, if we have some time, if people have questions, I just want to thank you. It's very informative as usual, and I feel like I should take your class if you give a class one day. But we have now James Love, who's the director of Knowledge Ecology International, and whose training is in economics and finance. But he works mostly on the production management and access to knowledge resources, as well as aspect of competition policy. He works, many of you know him for his work on access to medicine, but he's also a big access to knowledge expert. And also with Louis, he was very much involved in the push for the treaty for people with disability. And I'm going to give the floor to Jamie now, if I see him. Jamie?
I'm here.
Okay.
Can you see me? I'm gonna try and share my screen. I'm gonna talk about other areas of the law where, because of the pandemic, there have been concessions made for the pandemic. See if I can do this properly in terms of. I have too many screens open here. Let's see here. Let me try it again here. Yeah, I think this is right. Okay, can you see this okay? Is this being shared right now? My slides? I assume that this is being shared, so I'm going to just go through this.
It is. We can see it.
I'm going to talk about the way commercial rights have been influenced because of the pandemic. I'm going to start with a discussion of the United States. The first thing I want to mention is the United States Defense Production Act. And under this, the President of the United States, Donald Trump, has issued a series of executive orders and memorandums. This is a really powerful authority. It gives the United States government the right to take control of factories, to dictate manufacturing, to set prices, all sorts of things. these are the items on this list are really just a few of the executive orders and memorandums implementing the executive orders or the authority that have been issued beginning in March 18th of this year. There's also been a series of actions designed to prevent people from being evicted from apartments. So if you think about intellectual property, this is a contrast. This is real estate, which I think everyone would agree is property. And in these cases, in a number of situations, there have been measures that have been taken by the CDC and by other actions by the federal government and by state governments to prevent landlords from evicting tenants if they can't pay their rent. Let's see, going the wrong way here. This is a provision in the CARES Act, which has, it was initially going to take place from March 27th to July 24th, but it's been expanded to the end of the year. And it covers, it requires all kinds of concessions for tenants, and it covers people that receive federally subsidized and guaranteed loans. It's actually a large proportion of the financing mechanisms in the United States. If you own the house, the Congress has also required that people that lend money on mortgages, mortgage holders, banks, other lending agencies are not they're required by law to allow you to have forbearance, which is to say, to suspend the payment of your mortgage entirely during the period of the pandemic, or the period that's authorized on the pandemic. Now, this doesn't mean that you won't ever have to pay the money, but it means that you don't have to pay it now. And that's a concession to the fact that a lot of people lost their jobs during the pandemic. Student loan payments in the United States that are federally funded under the CARES Act have been suspended to the end of this year. And that includes the principal and the interest on the loans. And that's interest that you do not have to pay back. And this applies to federally held student loans, which is a large proportion of student loans in the United States. The United States Patent and Trademark Office has issued a whole series, by my count, roughly 20 notices relating to the COVID-19 pandemic. Among other things, they've declared that the coronavirus is an extraordinary situation for affected applicants, patentees, both for patents and trademarks. They've waived signatures, reduced fees or waived fees, extended deadlines, expedited examinations of certain trademarks and patents. So the Patent and Trademark Office really sees the pandemic as requiring extraordinary measures. The United States Copyright Office has also undertaken a series of measures related to COVID. And that the head of the Copyright Office has modified a number of provisions, primarily that affect copyright owners themselves on issues such as registration. The Office of Budget Management in the United States, or Management and Budget, I should say, issued a memorandum on the 19th of March that had a whole series of provisions that dealt with people that had contracts or provide services or grants from the United States government, having to do with everything you can possibly imagine in terms of the economic issues, the deadlines, and built much more flexibility into the system. Switching to the private sector, you see a number of publications, including journals like the New England Journal of Medicine, or news organizations like the Washington Post and the New York Times, others, have lifted the paywall restrictions on content that's related to the COVID-19 pandemic. You have seen there's a federal executive order that has to do with the designation of specific goods as scarce in the context of COVID-19. Some of it involves set issues as N95 masks, ventilators, certain drugs, sterilization devices, medical gowns and apparel, personal protective equipment. And these allowed a number of different steps that can be taken by the federal government to secure access to the supplies and to reallocate them. There's been initiatives on price gouging. There's forms of regulation of prices now that did not exist previously. And it's only related to the pandemic, so this is a special thing. More than 30 states have some sort of price gouging forms on their books, most of which are typically triggered by the declaration of a statewide or a national public emergency. There's an executive order by the president on price gouging. The Attorney General William Barr is initiating actions in this area. Internationally, the TRIPS agreement, when it relates to patents, does provide that you can waive certain conditions in the compulsory license of patents relating to the prior authorization attempts to achieve voluntary licenses before issuing a compulsory license, and issues about the compensation, which are waived in the case of a national emergency or other circumstances of extreme urgency. So these are certainly relevant to cases of a pandemic, but this applies for patents in the TRIPS. It does not apply to copyright. However, Article 73 of the TRIPS agreement is broader than the provision on patents. It applies to everything in the TRIPS agreement. And it says that nothing in the agreement can be construed to prevent a member from taking any action which it considers necessary for the protection of its essential security interest. And the South Center, in a series of papers, has highlighted this exception and encouraged countries to invoke this exception during the period of the pandemic, saying that the Article 73, subparagraph B exception applies for the COVID pandemic. Recently, on October 2nd, there was a communication from India and South Africa, and they've made a proposal for a waiver of certain provisions of the agreement for the prevention and containment and treatment of COVID. Their particular waiver goes to several issues. It goes to patents. It also goes to copyright, and goes to data. In the area of copyright, they have a carve out for performance rights, but they apply to other parts of copyright. And it also goes to rights and data related to the pandemic and know-how. In Germany, on March 27, 2020, they adopted a special law on compulsory licensing that allows the Minister of Health to issue what they call use orders for patents during the pandemic and during the emergency. So in Germany, any patent that stands in the way of getting any kind of treatment available in Germany during the pandemic can be waived immediately by the Minister of Health. Canada also passed a new provisions related to, in March, they also passed new provisions about the same time Germany did that deal with patent rights during the pandemic. So I'm going to stop that right here. I'm going to stop the sharing. I think that from our point of view, it's obvious that during the pandemic, lots of things are different. Schools are shut down in a lot of places. Libraries have restricted access or no access. And during that period, it seems normal to us that the function of libraries, that there should be mechanisms to allow libraries to function as well as possible, particularly with so many people that do not have access to schools as well and are required to do things like homeschooling or don't have access to the kind of materials you normally have in a school setting or with access to a library. I just wanted to go over those things because I think it provides some context in the particular case with the Internet Archives, where the issue is whether or not what they did in changing the rules of controlled digital lending during the pandemic were appropriate. Because I know that the Authors Guild has spoken out against it, and 4 large publishers have sued them. Thank you.
Well, thank you very much. I think we're running out of time, so I think we have about 2 minutes. I wouldn't mind if people were asking questions to Augustine first, because I think he has to leave early, right?
Oh, actually, it's fine. I can stay a bit longer.
So I would ask the speakers to ask a question, and I will start the roundabout by the one that raised his hand, whether he wanted or not. Stephen, do you have a question to ask your co-speakers?
I have a list of things I'm going to be looking into in more detail.
Okay. How about you, Corinne?
I don't have a great question off the top of my head. I guess I'm curious to hear more actually about the Latin American experience, because I think that's quite interesting. And I'm wondering if you have numbers in terms of how many people are taking advantage of the options that are available.
And that would be for Lewis to answer, I think.
Oh, okay.
I'm sorry.
Not for me.
Anyone has to answer this.
Okay. So I will be brief. Well, we in this moment we don't have I don't have any statistics on Latin America. My guess is in Latin America almost none is using, except in the case of Chile. In the case of Chile, we asked it to universities who are doing this, because to do the digitalization is costly. It's not any library can do it, and from around 13 libraries from a group of universities that are in a related to the government, only 2 of them were using, widely the possibility of digitizing and putting online to all of their students. So it still is a limited, but those who are using it, they are really exploding, the exception. So we still have to see the reaction from the right holders.
That was actually going to be my follow-up question, was the kind of the reaction that, and actually this for anyone on the panel, I'm curious in your respective jurisdictions, what you've seen in terms of challenges from publishers or other rights holder groups.
Well, I think that we're sometimes we worry about what we can share on listservs, which is not really controlled digital lending. It's more of a fair use issue, and we're wondering if it should be different during the pandemic for certain types of things which are really related to people understanding where things stand in terms of policies about the development of drugs or access to drugs and things like that. A lot of the best information is really behind paywalls. And so but the public interest in knowing these things is really intense right now. And so we would think that the 4-step test should move a little bit in the United States.
And I would add to this that very, very often I hear people focusing on CDL, which is part of an institution, whether it's through the university networks that the Hattie Trust has together, or the states where I live, or the school district where my grandchildren go to. But there's also a lot of people like me who are not affiliated to a specific library per se, and I'd like to have access to a lot of information or data or software or things that I'm used to get in a library, and I know it exists on a digital format, and I find it very, very frustrating that I can't get it unless I go back to my old university work and I'm linked to that. I can't get access. So Jamie was mentioning the public interest, and I think that's very important. There's a very broad public interest, and it's not just institutions, schools, and so on. It's also the public in general, which needs to be retrained, which need to learn things, because the world is getting to be different. And where do we learn how to be different ourselves, if not through reading and looking at digital information and knowledge goods?
I'd like to elaborate a little bit about the Copyright and the Patent Office in the United States. They've taken very aggressive steps to protect right owners. They have really not lifted a finger about thinking about the impact of intellectual property policies on the public during the pandemic.
Stephen, you wanted to say something?
Yes, just on Jamie's last point there, I think I mentioned in the call, we've got Australia is almost explicitly looking at updating its laws. We've seen the example from Hungary that Teresa Nobre detailed on a little bit earlier this morning, but obviously something coming from Viktor Orban isn't always welcome. In terms of how publishers have responded, it's important to sort of say, often the publisher lobby organizations will have to take the most extreme position because they're lobby organizations, that's what happens. We have seen plenty who have been sort of quite positive, quite open, and are giving access to things. Some of the time it's because they see it as a sales opportunity and they'll admit as such, and this has been documented in the press. I think one of the challenges though, and you get this from just looking at all of the commitments made to the ICOG, the International Coalition of Library Consortia, is that for all of the generosity, the problem is it always comes in different forms with different sell-by dates, with different possibilities, with different terms and conditions attached. And so while it's great that there's generosity, if it just forces libraries each time to go back and read the contract, it's not any easier to deal with. And arguably, and I think the points being made consistently here, we're not talking about things that should be reliant on goodwill or reliant on someone being in a good mood or being sort of sufficiently enlightened to provide access. There needs to just be this guarantee that these sort of basic uses, public interest uses, should not be something that's a risk factor in this. There's plenty of risk factors out there. If we want to manage risks in the future, that when another pandemic comes, there's a way of reducing this risk.
Do you all think that there should be an international solution to this, or should we keep doing the national and exception by exception with playing with different things? I mean, what's your thinking about international solution? You can unmute yourself, Augustin.
Yeah, if I can, chip in on that. Realistically, I think it's difficult to talk about international solutions, especially when we have quite differentiated systems. And actually picking up on what Stephen has just said, the idea of having an exemptions-based system is to reduce that risk. Because one of the reasons why, for example, we don't have fair use in Europe is to avoid the risk of litigation, because ultimately you end up before a court and you need to prove that you fall under this general clause. Ideally, we should have a combination of both systems, but the principle of having exemptions and limitations is exactly to prevent that risk. And I found incredible that, like Stephen was saying, that if you need to go back every time to your contract terms, for each single publisher, which in the case of a library can imply a quite extensive list of contract terms, why on earth do we have exemptions, which have been designed to give legal certainty, both to right holders and also to the beneficiaries of the exemptions? So I think that here we really have a case for have more clarity rather than reinvent the system, because exemptions are there. The simple fact is because they are so unclear that they are not used in practice.
But maybe the contracts, the contractual terms are sometimes undermining the exception. And I think that is, you can clarify the exception all you want if by contract and the negotiation is totally unfair in the sense that libraries have a public interest mandate, so they have to provide the information. So you can see that the negotiations are intrinsically unfair. That's why, in a way, the system of exception and the system of contracts for libraries is just exploding right now, I think, and we're all in bad shape. I think that I was in a meeting last week at the American University College of Law, which was extremely interesting, and where they explore the idea that most systems have some kind of fair use. All systems are a little bit hybrid because otherwise they wouldn't work. And I thought that was a very interesting point. And I think that I understand the exception, being French myself. I didn't know about fair use until I moved to this country, and I love it. But I understand that it's not a concept that, as a block, can be just pushed into every jurisdiction. But having said that, I do think that we should have an unfair contract solution, how to deal with the unfair contracts. And I know that publisher had a little bonus in the UK 20 years ago when they got exempt from unfair contracts.
I think
So maybe we should reverse that now.
the governments in a lot of areas, they just make some contract provisions just illegal. Like in landlord-tenant law, you can't put whatever you want in a contract with a tenant. And so I think the idea that there are limits to what you can do contract. There's a provision in the TRIPS agreement on unfair contracts as well, Article 40, which really green lights the idea that you can deal with unfair contracts. So between the first sale doctrine, the provision on unfair contracts, I think you have a lot of flexibility in terms of the international framework. The other thing that Louise brought up at the previous seminar was that if you fashion exceptions as limitations and remedies, they're not subject to the three-step test. And that was, in fact, what the Librarian of Congress proposed in the US for our orphan works legislation some years ago. And I think that that should be discussed. So this issue of unfair contracts, relationship contracts, and exceptions, and the limitations and remedies should be the focus of the reform agenda.
Well, thank you. I think we are being told by the master of all technologies that we reach our endpoint. I think that we should have another Zoom webinar on unfair contracts soon. I thank you all for being here and enlightening us about what's going on. And I hope to see you soon in real life too, because there's a little bit of Zoom fatigue, of course. Goodbye.
Thank you.
Thank you.
Thank you very much.
Thank you, Benno.
Everyone.